Imagine this. You are in the hospital. Maybe it was a fall. Maybe it was your heart. Maybe it happened so fast you barely had time to understand what was going on. And now you are lying in a hospital bed, unable to speak clearly or unable to make decisions for yourself. Your family is in the hallway. They are frightened. They want to help, but the doctors are asking them questions they cannot answer. What medications are you on? Who has the legal right to make medical decisions for you? Do you want to be kept on life support if your heart stops? Where is your will? Does anyone have access to your finances to pay your bills while you are here? Your family does not know. Not because they do not love you, not because they were not paying attention, because you never had the paperwork ready. Now here is the hard truth that most people spend years avoiding. This situation happens every single day across America, to families just like yours, to seniors who were perfectly healthy last Tuesday, to people who always said they would get around to it, eventually. And the tragedy is not the illness or the accident itself. The tragedy is that without 5 specific documents in place, just 5, the people you love most are left scrambling in one of the worst moments of their lives. Courts get involved, family members disagree, bills go unpaid, wishes get ignored. But here is the hopeful part, and this is important. Every single one of these problems is completely preventable. 5 documents. That is all it takes to protect yourself, protect your family, and make sure your wishes are honored, no matter what life brings. Today we are going through all 5 of them. What they are, why each one matters, what happens if you do not have them, and exactly what to do to get each one in place, clearly and simply, without the legal confusion that most people find overwhelming. One of these documents, number 3, is one that shocks almost every senior who learns about it for the first time. Not because it is complicated, but because of how few people actually have it ready and how much damage that gap causes for families every single year. Stay with me all the way through. This may be the most practically important video we have ever put on this channel. Let us begin. Welcome. If you are 60, 65, or anywhere near that age, or if you love and care for someone who is, this video was made specifically with you in mind. We talk a lot on this channel about taking care of your body, exercises, nutrition, brain health. All of it matters deeply. But today we are talking about something that is just as important, maybe more important than most people want to admit. We are talking about protecting yourself legally and financially, about making sure that if something unexpected ever happens to you, your family has the tools they need to honor your wishes, handle your affairs, and take care of you the way you actually want to be cared for. This is not a scary conversation. It is an empowering one. Because every senior who has these 5 documents in place tells the same story afterward. Relief. A deep, genuine sense of relief that comes from knowing that no matter what happens next, the people they love will know exactly what to do. That is what today is about. Let us start with a story. Margaret's story. You may remember Margaret from our earlier videos. She is 68 years old, retired, sharp, organized, and thoughtful about her health. Last spring, Margaret's older sister Eleanor had a stroke. Eleanor was 72, healthy until that Tuesday morning, active, independent. The stroke left Eleanor unable to speak and unable to make her own decisions. The family rushed to the hospital. Margaret was there within hours. And then the chaos began. The hospital needed someone with legal authority to approve Eleanor's treatment plan. Nobody in the family had that authority on paper. The doctors were doing what they could, but certain decisions had to wait. Eleanor's daughter tried to access Eleanor's bank account to keep her bills paid while she was hospitalized. She could not. No legal access had ever been set up. When the family asked what Eleanor would want if she did not recover fully, nobody could agree. Eleanor had spoken generally about her wishes over the years, but nothing was written down. Nothing was legally documented. It took weeks to sort out. Lawyers were involved. Money was spent. Family relationships became strained under the pressure. Margaret sat in that hospital hallway and made herself a quiet promise. She was going to go home and get her own paperwork done. Every document. No more putting it off. She kept that promise. And today she says getting those 5 documents in order was one of the most loving things she has ever done. Not for herself, but for her children. That is the spirit of today's video. Why this matters, and why now. Before we go through the 5 documents, let me spend just a few minutes on something that trips most people up. The question of why now? Why not later when things feel more urgent? Here is the answer most people do not want to hear. The time to prepare these documents is always before you need them, not during a crisis and not after. Here is why that matters so much. For most of these documents to be legally valid, you must be mentally competent when you sign them. That means you must be of sound mind, able to understand what you are signing and why. If illness, injury, or cognitive decline has already begun to affect your mental clarity, many of these documents cannot be created in the way they need to be. This is one of the most heartbreaking situations families face. A parent who waited too long and whose documents can no longer be properly prepared because they are no longer legally considered able to make those decisions for themselves. The second reason is equally important. Legal documents take time. Finding the right professionals, completing the necessary steps, and making sure everything is properly signed and stored does not happen overnight. You want this process done calmly, clearly, and without the pressure of a medical emergency waiting on the other side. Age 65 is not an arbitrary deadline. It is when Medicare begins. It is a natural milestone when many seniors are transitioning from work to retirement, from employer health plans to government coverage. It is the right time to make sure every piece of legal and financial protection is already in place. If you are already past 65 and do not have these documents ready, please do not feel behind or guilty. Just focus on getting started as soon as possible. Let us go through all 5 documents now. Gonung 1. The Last Will and Testament. Making sure your wishes are followed after you are gone. The first document every senior must have is a last will and testament. Most people simply call it a will. A will is a legal document that tells the world, and more specifically the courts, exactly what you want to happen to your belongings after you pass away. Who gets your home? Who gets your savings? Who gets your car, your jewelry, your furniture, your family heirlooms? If you do not have a will, here is what happens. The state you live in decides. Using a standard set of rules called intestacy laws, a court will distribute everything you own according to the law, not according to your wishes. The people you wanted to receive things may not receive them. The causes you cared about will receive nothing, and your family will spend significant time and money going through a legal process called probate that is far longer and more expensive without a valid will in place. Let us be very specific about what a will does and does not cover, because this is where many people get confused. What a will covers. It names your beneficiaries, the people or organizations who will receive your assets. It names an executor, the person responsible for carrying out the instructions in your will and managing the legal process after your passing. It can specify particular items for particular people, like a piece of jewelry for a specific grandchild, or a car for a specific son or daughter. And importantly, if you have minor children or grandchildren who depend on you, a will is where you name a guardian for them. What a will does not cover. A will does not cover assets that have their own beneficiary designations already in place. These include life insurance policies, retirement accounts like an IRA or 401k, and any bank or investment accounts that are set up as payable on death to a named person. Those assets pass directly to the named beneficiary regardless of what your will says. This is why keeping your beneficiary designations up to date on all of those accounts matters just as much as having a will. How to create a will. You need a licensed attorney to create a legally valid will in most states, though a small number of states accept what is called a holographic will, handwritten and signed by you without an attorney present. However, for something this important, working with an elder law attorney or estate planning attorney is strongly recommended. The cost is typically a few $100s and is absolutely worth the protection it provides. Once your will is completed, keep the original in a safe place, a fireproof safe at home or a safe deposit box at your bank. Make sure your executor knows exactly where it is. A will that cannot be found after you pass away is almost as problematic as not having one at all. Review your will every 3 to 5 years, and after any major life event, a marriage, a divorce, the birth of a grandchild, the death of a beneficiary or executor. Life changes, and your will should keep up with it. Document 2. The durable power of attorney. Giving someone you trust the legal right to manage your affairs. The second document every senior must have is a durable power of attorney, often shortened to DPOA. This document gives another person, someone you choose and completely trust, the legal authority to manage your financial and legal affairs on your behalf. This person is called your agent or your attorney in fact, though they do not have to be a lawyer. They can be your spouse, your adult child, a close, trusted friend, anyone you believe would handle your affairs with care and integrity. The word durable is critical here, and it is what separates this document from a standard power of attorney. A standard power of attorney becomes invalid if you become mentally incapacitated. A durable power of attorney remains valid even if you lose capacity, which is exactly the situation where you need it most. What your agent can do with a DPOA: pay your bills and manage your bank accounts while you are unable to do so. File your taxes. Manage your investments. Handle real estate transactions on your behalf. Deal with government agencies including Social Security and Medicare. Make financial decisions necessary to fund your care during illness or recovery. What your agent cannot do. A DPOA does not cover medical decisions. That is handled by a separate document, which we will cover in just a moment. A DPOA also ends the moment you pass away, after which your executor will take over. Why this matters so deeply. Here is a situation that happens constantly in American families. A senior becomes ill or incapacitated, even temporarily, even for a few weeks, and nobody has the legal authority to pay their mortgage, their utility bills, or their insurance premiums. Bills go unpaid, accounts fall behind. Property can even be lost during a prolonged hospitalization, simply because no one had the legal right to manage things in the interim. Without a DPOA, the only option available to your family is to go to court and request legal guardianship over your financial affairs. This is a lengthy, expensive, emotionally draining legal process that can take months, and all of it is entirely avoidable with one document prepared in advance. How to create a DPOA. An elder law attorney can prepare this document for you. In many states, it must be signed in the presence of witnesses and a notary public to be legally valid. The cost is typically modest, especially when bundled with your will and other estate planning documents. Choose your agent carefully. This is someone who will have significant access to your finances during a vulnerable time in your life. Trust, honesty, and good judgment matter enormously in this choice. Once signed, give a copy to your agent, your bank, your financial advisor, and your attorney. Make sure the people who would need to use it actually have it available. Documents 3. The Advance Healthcare Directive. Making sure doctors know what you want, even when you cannot tell them yourself. Here it is. The document I mentioned in the opening of this video. The one that shocks almost every senior when they truly understand it for the first time. Document 3 is an Advance Healthcare Directive. Depending on your state, you may also hear it called a living will, a healthcare proxy, or a combination of these. The specific name matters less than the concept, which is this. This document tells your doctors, your hospital, and your family exactly what medical care you want and do not want. If you ever become too ill or too injured to speak for yourself and make those decisions in real time. Here is why this shocks people. Studies consistently show that the majority of American seniors do not have this document in place. The majority. Yet every single day, families across America are placed in the devastating position of having to make life and death medical decisions for a loved one they cannot communicate with, without any written guidance from that person about what they would actually want. These moments tear families apart. Children who disagree with each other about what their parents would have wanted. Spouses who are paralyzed by uncertainty and guilt. And medical teams who must act conservatively without clear guidance, sometimes in ways the patient would never have chosen. What an Advance Healthcare Directive covers. It typically has two main parts. The first part is a living will. This is where you document your specific medical preferences. Do you want to be placed on a ventilator if you cannot breathe on your own? Do you want a feeding tube if you cannot eat? Do you want aggressive resuscitation efforts if your heart stops? Do you want to be kept alive by machines in a state with no realistic hope of recovery? Or would you prefer comfort care only? These are deeply personal questions, and only you can answer them, but you must answer them in writing while you still can. The second part is a healthcare proxy, sometimes called a medical power of attorney. This is where you name a specific person, separate from your financial power of attorney, though it can be the same person if you choose, who has the legal authority to make medical decisions on your behalf if you are unable to make them yourself. This person speaks for you in the hospital room. They communicate with your doctors. They make the calls you cannot make. How to create an Advance Healthcare Directive. Requirements vary by state, but in general, this document must be signed in the presence of witnesses and often a notary public. Many hospitals and doctors' offices can provide state-specific forms, and organizations like AARP also provide free templates and guidance for every state. Once completed, do not keep this document only in a safe at home. Give a copy to your primary care physician to keep in your medical file. Give a copy to your named healthcare proxy. If you are ever hospitalized, bring a copy with you or make sure the hospital has it on record. A document that exists but cannot be found in the moment of crisis is not doing its job. This document is perhaps the most personal on this entire list. Having a calm, honest conversation with your family about what it contains before any crisis occurs is one of the most loving gifts you can give the people who will one day be asked to make these decisions for you. Do not leave them guessing. Tell them, put it in writing, and make sure they can find it when they need it. We are just past the halfway point, and the next two documents are ones that most seniors have genuinely never thought about. Not because they are obscure, but because almost nobody explains them to seniors the way they deserve to be explained. Document 4 is something that can prevent your family from losing years of savings to completely avoidable government processes. And Document 5 is the one that most people discover they need only after a medical crisis has already begun, when it is already too late to prepare it in the way it needs to be done. Stay with me. Document 4, a Revocable Living Trust. Keeping your estate out of court and your family out of conflict. Document 4 is a Revocable Living Trust. This one surprises many seniors because most people assume a will is all they need to ensure their assets are properly passed on to their loved ones. And a will is a vital document. We covered that already. But a will has one significant limitation that most people are never told about. Everything passed through a will must go through probate, the public court process that validates the will and oversees the distribution of your estate. Probation takes time. In many states, it takes anywhere from several months to more than a year. During that time, your family cannot access the assets being distributed. Probate also costs money, court fees, attorney fees, and administrative costs that can consume a meaningful percentage of your estate. Probate is also public. Anyone can look up a will once it has gone through probate court. Everything you owned and everyone you left it to becomes part of the public record. A revocable living trust solves all three of these problems. How a living trust works. You create a legal trust, think of it as a container, and you transfer your major assets into that container during your lifetime. Your home, your bank accounts, your investments. You name yourself as the trustee while you are alive and capable, which means you retain complete control over everything inside the trust. You also name a successor trustee, someone you trust, who takes over management of the trust if you become incapacitated or when you pass away. At your passing, your successor trustee distributes everything in the trust to your named beneficiaries. Without going through probate, without court involvement, without public record, and without the months of waiting that probate requires. The word revocable matters. This kind of trust is fully revocable, meaning you can change it, update it, add to it, or cancel it entirely at any point while you are alive and mentally competent. It is not a permanent or fixed arrangement. You remain in control throughout your lifetime. What a living trust does not replace, a living trust does not replace a will. Most estate planning attorneys recommend having both a living trust for the assets held inside it. A pour-over will make sure that any property or assets you forgot to transfer into your trust while alive will be moved into the trust after you pass away and direct them into the trust at that time. A living trust also does not provide any tax benefits on its own. There are other more complex trust structures for tax planning purposes, which an estate planning attorney can discuss with you separately if relevant. How to create a living trust. This document requires an attorney and will cost more than a simple will alone, typically ranging from a few hundred to a few $1,000s depending on the complexity of your estate. However, for seniors with significant assets, particularly those who own real estate, the cost of setting up a living trust is almost always far less than the cost of going through probate. Discuss this option seriously with an estate planning attorney. For many American seniors, it is one of the most important financial decisions. The fifth document, a HIPAA Authorization Form, the simple document that lets your family help you when it matters most. The fifth and final document is one that almost nobody talks about, and the one that catches families most off guard in the middle of a medical crisis. It is called a HIPAA Authorization Form. HIPAA stands for the Health Insurance Portability and Accountability Act. This is the federal law that protects the privacy of your medical information. Under HIPAA, your doctors, nurses, and healthcare providers are legally prohibited from sharing your medical information with anyone, including your own adult children, without your written permission. Most people assume that if they are hospitalized, their family members will automatically be kept informed about their condition, their test results, their treatment options, and their prognosis. This assumption is incorrect. Without a signed HIPAA authorization form on file, a hospital doctor cannot legally tell your daughter what your blood test results showed. A nurse cannot confirm your diagnosis to your son. Your physician cannot discuss your treatment plan with your spouse if the two of you are not legally married, or in some cases even if you are, depending on how the situation presents. This creates a situation where family members who are desperately trying to help, who may have traveled across the country to be at your side, are legally blocked from getting the basic information they need to support you and make good decisions on your behalf. What a HIPAA authorization does, it gives you the ability to name specific individuals, as many as you choose, who your healthcare providers are legally permitted to speak with openly about your medical care. Your children, your siblings, a close friend, a neighbor, whoever you want in your circle of trust for medical information. This is separate from your healthcare proxy named in your Advanced Healthcare Directive. The healthcare proxy makes decisions for you. The people named in your HIPAA authorization simply receive information. Both are important, and they can name the same people or different people. your choice. How to complete a HIPAA authorization. This is one of the simplest documents on today's list. Most hospitals, doctors' offices, and medical clinics have their own HIPAA release forms available, and many will complete the process right there during a regular appointment. You can also find HIPAA authorization templates online, though if you use one, make sure it meets your specific state's requirements and that it is signed and witnessed properly. Most importantly, once this form is signed, give it to your primary care physician and make sure it is on file at every medical facility where you regularly receive care. If you are ever admitted to a hospital, let the admissions staff know that you have a HIPAA authorization and provide them with a copy. One final note on this document. Many seniors complete a durable power of attorney and an advanced healthcare directive and believe their family communication issues are fully covered. But without a HIPAA authorization, your healthcare proxy named in your advanced directive may still face barriers when trying to gather information from medical providers in certain situations. Do not overlook this one. It is simple, free, or nearly free to complete, and in a medical crisis, it makes an enormous practical difference. Let us bring all 5 documents together in one clear, simple summary. Document 1, the last will and testament. This tells the courts and your family exactly what you want to happen to your belongings after you pass away. Without it, the state decides for you. Document 2, the durable power of attorney. This gives a trusted person the legal authority to manage your finances and legal affairs if you become unable to do so yourself. Without it, your family may face court proceedings just to pay your bills. Document 3, the Advanced Healthcare Directive. This tells your doctors and your family exactly what medical care you want if you cannot speak for yourself. Without it, the people you love are left guessing, and family conflict and unnecessary medical interventions are far more likely. Document 4, a Revocable Living Trust. This keeps your major assets out of probate court, saving your family time, money, and privacy during an already difficult time. Document 5, a HIPAA Authorization Form. This gives your chosen family members the legal right to receive your medical information from your healthcare providers. Without it, even your closest loved ones may be legally blocked from getting the information they need to help you. 5 documents. Each one serves a different but essential purpose. Together, they form a complete legal and medical safety net for you and for everyone who loves you. Here is a simple action plan to get started. Step 1. Write down the 5 documents from today's video. Check off any you already have in place. Be honest with yourself about the ones you do not. Step 2. Contact an elder law attorney or estate planning attorney in your area. Many offer a free or low-cost initial consultation. Tell them you want to review or create your will, power of attorney, healthcare directive, and living trust. A good attorney will guide you through all of them in a coordinated way. Step 3. Complete your HIPAA authorization at your next doctor's appointment. Ask the receptionist for the form before you leave. Step 4. Once your documents are completed, make sure the right people have copies. Your executor should have your will. Your agent should have your power of attorney. Your healthcare proxy should have your healthcare directive. Your doctor should have your healthcare directive and HIPAA authorization. Step 5. Put the originals somewhere safe, a fireproof home safe or a bank safe deposit box, and tell your most trusted family member exactly where they are. That is it. 5 steps. None of them are complicated. All of them are genuinely protective of you and the people you love. Let us come back to where we started. That image of a family in a hospital hallway, frightened and uncertain, unable to answer the questions being asked of them. That does not have to be your family story. It does not have to be your children standing in that hallway, unable to help. It does not have to be your wishes that go unheard. 5 documents. That is all that stands between a family in crisis with no direction and a family in crisis with everything they need to take care of you the way you deserve to be taken care of. Margaret, who we met at the beginning of this video, completed all 5 documents within 6 weeks of watching her sister's family struggle through the aftermath of Eleanor's stroke. She told her daughter afterward, "I thought getting these done was something I was doing for myself, but sitting here now, I realize I was doing it for you." That is the spirit of these documents. They are not paperwork. They are love letters to your family, written in legal language but rooted in the deepest kind of care. Do not wait for a Tuesday morning when everything changes. Do it now while the doing is easy. If this video helped you today, please take just 1 second and click the like button below. It genuinely helps this information reach other seniors and families who need it. I would love to know in the comments, which of these 5 documents do you already have in place, and which ones surprised you most today? Many people are genuinely surprised to learn about the HIPAA authorization and the Living Trust. Let us know where you are starting from. And if someone you love needs to hear this, a parent, a sibling, a close friend who keeps putting this off, please share this video with them. Sometimes the most loving thing you can do for someone is to make it easy for them to start. We will be back next week with more practical, honest guidance on living well, staying healthy, and feeling fully prepared for whatever comes next. Take care of yourself and take care of the people who love you. See you in the next one.